Supplementary list for hearing under the 41 Rule 11, item 403. Second appeal 579 of 2017.
Yes. Yes, ma'am.
From delegates for hearing under the 41 Rule 11, item 23. Second appeal 36 of 2022.
This case of appeal number 2 also
SC number 36 of 22. When did he die?
in the year 2023 also.
The learned counsel for the appealant has submitted that appealant number 2 has expired sometimes in the year 2023. Accordingly, this appeal, so far as appealant number 2 is concerned, is abated. However, he seeks judgment. Next week.
Definitely 2 weeks time.
On 4th of December, 3rd of December.
Item 24. Second appeal 70 of 2025.
Yes.
And then appeal relates to partition logic. There is concurrent finding of the court of law. तो किस अगर प्रिंटिंग इज दैट उनका कहना है कि प्रॉपर्टी जॉइंट टाइटल था प्रीवियस कोई पार्टीशन नहीं था डिपेंडेंट का कहना है कि नहीं दे वर सेपरेटेड बाय द मेस रेसिडेंस सेपरेट कल्टीवेशंस and they are separated from ancestor to ancestor, more or less they are in third generation. Now, I like to draw the attention of the concluding page of the appeal order. Learned trial court, even appellate court, they have rejected the partition on the ground that Kabjawari Khata is not enough manifest, does not manifest enough proof of a partition. They have rejected, and they have given primacy to the mutation. On basis of mutation, they have given a finding that land is joining ancestor property is joining possession. Now, Lordship, my submission.
You are the defendant?
Presently, I am the defendant, Lordship, and the appellate.
You are the defendant. The partition suit has been allowed.
Partition has been allowed. It has been reopened, Lordship. In case we can say that.
Why do you say? Was that your case that there was ever any partition, or your case was there was never any partition?
Our case is that there was obviously previous partition as per the possession in the Kabjawari Khata. Remarks follow the name of each of the
Previous partition when?
Actually, it has not been specific finding in the court there that in which year the partition. There is no documentary or oral direct evidence.
Is there any finding that there is whatever mutation etc. is there that is equitable?
No, they have given on the basis of mutation. They have given a finding trial court, I mean appellate court, that landed ancestral property is a joint property. They have given as such. So they have decreed partition if you are half the share in favor of the printing as such. Our case is that Lordship, mutation is a mode of payment of a tax. Even Supreme Court has stated in various categories.
Mutation is also an evidence of possession.
But this is one of the criteria. The most important test, Lordship, for a partition is that intention of the parties, how they enjoy their share, and other evidences has to be relied upon. Circumstantial conduct of the parties, oral evidence.
Is there any transaction amongst them?
There is no transaction of any sale deed, Lordship, but one vital piece of evidence has been overlooked, that the defendant have constructed a house in their own land which was in possession. plaintiff they never objected for many years. This finding has been overlooked by both the court.
No, that doesn't make any difference. Anybody can make construction over the property.
If there is a division, separation of the share in the property lordship, obviously they should have objected.
No, they will never object.
No, the question is that
In a joint family, if somebody is undertaking some construction, nobody is going to object to that.
this partition to lordship has been filed in the third generation.
So,
Well, if the co-sharer lordship, they are in the first brother lordship, there is strong presumption of the jointness of the family. But second to third generation is presumption gets weaker lordship, and there is more presumption is more strong that family joint family status as serious lordship. This is my other case.
you see, even the rent is being jointly remitted.
Rent lordship, that is only
No,
payment of the tax. It
No,
cannot be conclusive
no,
proof.
it's not like that.
Ah.
If there has been a partition, why would two persons join together to give rent?
What other vital evidence is
Then
that?
it means that they are still enjoying this. This is the finding recorded by
Recorded by
the.
both the court below.
Right.
Now, what plenty witnesses, their own
It
witnesses.
is a respectable finding.
Plenty
It is no perversity. You have concurrent findings of both the
I
courts.
do agree, lordship.
You have to show something very, very glaring to show that something has been missed out or something has been illegally taken into consideration.
Plenty witnesses, lordship, they have stated that the parties they are separated from their ancestors, from everything. One witnesses, 3 to 4 witnesses, lordship, has been Para have mentioned in my petition. Part PW1 cross examination 19-20-21. I just go through it, lordship. PW2 cross examination Para 20.
That is not sufficient.
The overall evidence has been overlooked by the trial.
No. There is no question of overlooking of oral evidence. The the evidences have been taken into consideration, and oral evidence has to be read with the documentary evidences placed on record. You just cannot say. And who is this person, PW1? Who is he? PW1, how is he related to the family?
PW1 Jetta lordship.
Who is he?
Jetta is defendant number 1 trial before the trial court.
PW1.
PW1 is Jetta.
Jagtaura. So who is he? How is he related to the family?
He is the son of Bhairav Rao. May I give the genealogical table lordship for my lordship convenience?
You say that PW1 is the witness.
PW1.
PW1, how, when he is defended, how will he become a plaintiff witness?
PW1 is Radhe Rao.
Who is Radheora?
Radhe is PW1.
Yes, you were referring to the evidence of PW1, Radheora, right? Radheora तो इसमें कहीं है ही नहीं.
ये राधे रॉ के प्लेंटिफ है PW3 में. एडिशन सेशन सिविल ऑर्डर है राधे रॉ प्लेंटिफ नंबर 3 लॉर्डशिप.
Radheora.
राधे है. इनका एविडेंस पढ़ता हूँ. क्या कहते हैं? रेलवे पारा से. पार्ट 2 विवादी जमीन में दोनों पक्ष अलग अलग खेती करते थे. मैं जब से होश संभाला तब से लोग अलग अलग खेती करते हुए देखा हूँ. दोनों पक्ष बाप आजत से समय से अलग अलग खेती करते थे. दोनों पक्ष का खाना पीना रहना कारोबार अलग था. इसलिए दोनों में किसी प्रकार कोई पैदावार एक दूसरे को नहीं देते थे. They never shared the fruits that enjoy worship. The true test of the partition worship, if you go to the very school of law,
You
is the
see,
intention of the
there
partition.
has to be partition and there has to be partition by meets and bounds.
Which-
Both the things. Merely because somebody is occupying some property, other is occupying another property and dealing with it themselves, that is not a proof of partition. Partition has to be by meets and bounds. So, in absence of any such proof that there has been a partition by meets and bounds, the partition suit has to.
For a partition, it's not necessary some direct or written or documented.
That's right. It's not necessary.
It not.
But the partition has to be meets and by meets and bound in the sense if there are two brothers, it should be more or less half and half, right? So unless you are able to demonstrate that the occupation of the property with respect to each one of them was to the extent that it was by meets and it can be assumed that there has been a partition by meets and bounds. It cannot, the partition suit will not create an absence
They
of
are saying
that.
they are residing separately, cultivating separately.
No,
They are not sharing their fruits.
even if they are not sharing the fruits, it is immaterial. भाई हमने सोचा कि भाई ये घर आपका, ये घर मेरा, right? आप इसका किराया उठाइए, हम इसका किराया उठाएंगे. Possible? In a joint family, it is possible, right? Not a case. Not a case for framing substantial question of law. Not a case.
Government also got one high court judgment. Establish it is the
Yes, I'll see that. Right.
Only difference is that in their sale joint property पे सेल भी डिफेंडेंट मिला है जो सेल प्रिवेंटिव पे सेल कर दिया था ये डिफरेंस है हमारे
फर्क है ना बहुत फर्क है that is why I asked you there are cases that I have also decided there are cases when plaintiff is selling the property to defendant right so that sale itself shows that the defendant and plaintiff are otherwise separated
एक जजमेंट एक बार देख ले फिर आगे गुड व्हाटएवर ऑर्डर इन पास
which paragraph are you referring to
so every para has been marked by the pencil also
for the letter counsel appealing on behalf of the appellants. This appeal has been filed against the judgment dated 23/8/24 within bracket decree dated Q9/24 bracket close passed by the District Judge 1 Lohardaga in civil appeal number 3 of 22 affirming and confirming the judgment dated 25/2/2022 decree dated 8/3/2022 passed by learned Junior Additional Civil Judge number 2 Lohardaga in partition suit number 30 of 2015. The suit for partition was decreed by the learned trial court and the appeal was dismissed. Consequently, the defendants are the appellants before the suit. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the court that there has been no previous partition, but while recording such finding, the evidence of PW1, namely karma around, the evidence of PW1, namely Radhe Around, who was plaintiff number 3, has not been properly considered. He submits that PW1 had stated in his cross-examination that both the parties were separate in mess and cultivation, and they were cultivating separately since the lifetime of their father and grandfather. And therefore, it was sufficient to prove that there was previous partition. ये क्या हिंदू लोग हैं कौन है?
नहीं ट्राइबल्स हैं.
The learned counsel has submitted that the parties belong to the community of Oraon tribe, and इनके भी होता है presumption of jointness.
more or less guided रहते हैं हिंदू लॉ से.
The learned counsel has submitted that there is also a presumption of jointness with respect to their family. However, he has submitted that the evidence of PW1 was enough to substantiate that there was previous partition. Correct? After hearing the learned counsel appealing on behalf of the applicants, this court finds that suit was filed by 3 plaintiffs who are three plaintiffs, namely Karma Oraon, Laita Oraon,
and Radhe.
both sons of Pila Oraon, and Radhe Oraon, son of Vasudev Oraon. And defendants were Jagta Oraon, Jagan Oraon, and Suraj Oraon, contesting defendants. Death भी हो गया लगता है एक आदमी.
लेटर ना बच्चे भेज कर एक्टिव को उनके नाम सूची पर भी बच्चे से.
The learned counsel has also pointed out that Laita Oraon died during the pendency of the appeal, first appeal, and he was substituted. The suit was filed seeking a preliminary decree for partition of half interest of the plaintiffs over the suit land of Schedule A. It was asserted that the parties belong to Scheduled tribe and they are governed by their own customary law for the purposes of succession and inheritance. As per the divisional survey settlement record of rights, the property was recorded in the name of Bhairo Oraon, Suraj Oraon, both sons of Mahadev Oraon, Tila Oraon and Lalu Oraon, both sons of Saidev Oraon, and Chotia Oraon, son of Jharkhand Oraon. And were having equal share with respect to the property. It was the case that the plaintiffs and the defendant number 1 to 3 are the descendants of the recorded tenants of the suit property, and the genealogical table was also produced. One of the recorded tenants, namely Bhairo Oraon, died leaving behind his 4 sons. And the defendants are sons / grandsons of Bhairo Oraon. Correct? The plaintiffs were the sons / grandsons of Tila Oraon. It was the case of the plaintiff that the property was in joint possession and there has never been any partition with respect to the suit property during the lifetime of their ancestors. And even in the re-divisional survey record of rights, the suit was jointly recorded in the name of Bhairo Oraon, Suraj Oraon, Karma Oraon, son of Tila Oraon, Lalita Oraon, son of Tila Oraon, Vasudev Oraon, son of Tila Oraon, and Sani Oraon, son of Tila Oraon. It was also asserted that the plaintiffs and defendants are cultivating separate lands for the sake of their convenience, but they were still in joint possession of the suit land, and there has never been any partition by means and bond between the plaintiffs on the one hand and defendant number 1 to 3 on the other hand. And there was unity of title and possession. The defendant number 4 was the deputy commissioner being the pro forma defendant. as the parties were belonging to scheduled trade. It was asserted that the dispute and differences had always arisen between the parties for division of the share by meets and bound and for production and payment of rent relating to the suit properties. It was further asserted that the defendant number 1 to 3 were negotiating to sell the suit property to outsiders, and there has also been a temporary injunction. Sorry. And the plaintiffs approached the defendants for amicable partition, but they refused, and ultimately the suit was filed. The defendants filed the written statement stating that the suit was not maintainable. Barred by non-joinder, misjoinder of necessary parties, adverse possession, barred by limitation, waiver, recusance, stopping, and barred by the basis of section 34 of the Specific Treaty Act. It was a case of the defendants that there was misdescription in connection with the suit property. The defendant admitted that RS Khata number 62 of village Ita stood recorded in division survey of record of rights in the name of Bhairo Rao, Lalu Rao, Chotia Rao, but denied that there is entry of equal share in the Layat column. It was also asserted that in RS Khata number 62 is a Kabjiwari Khata in which in the remarks column possession of each co-sharer according to the partition and division of the property has been recorded. And in the survey, 3 types of khatas were prepared. They are Kabjiwari, joint and mixed. The case of the defendants was that Kabjiwari khata was enough to establish that there has been partition by meets and bound amongst the recorded periods. According to the entry of possession made in the remarks column. The defendant also gave the properties which were allocated to Vahedia Unnao and Suraj Unnao in Khata number 62 and total area allocated to them was 5.01 acres. Then with respect to Lalu Unnao and Tila Unnao, in Khata number 62, their share was 2.24 acres. And with respect to Chotia Unnao, in Khata number 62, the allocation was 3.11 acres. It was also Further details in connection with the allocation and possession of the shares in RS Khata number 62 was narrated by the defendants in their written statement. It was their specific case that partition had already taken place amongst the recorded rayet prior to publication of divisional survey record of right. And accordingly, Kabjiwara was prepared, and later on, after the death of Chotia Orao, who died issueless, his land was mutually partitioned. And hence, the question of undivided interest of the plaintiffs did not arise. In the additional, the defendants had also filed additional written statement stating that though new survey of record of rights was prepared jointly, but partition by meets and bond had already taken place amongst the ancestors of the plaintiffs as well as the defendant number 123 long ago. And accordingly, Kabjiwara was prepared in RS Khata number 62. It was asserted that the new survey, plot number 538, area 69 decimal, which was described under new survey Khata number 108 in Schedule B, does not correspond to the land in RS Khata number 62. It was also asserted that the new survey plot number 538, area 69 decimal, corresponds to RS Khata number 134, plot number 524, area 73 decimal, which stood recorded in the name of Bhairav Rao and Suraj Rao, sons of Manadev Rao, who had acquired their posted land by rendering service to the ex-landlord, and it was their self-acquired property. And the defendants claimed that they are the exclusive and valid owner in possession of their posted plot. It was also asserted that during the subsequent survey operation, since the defendants were not present in the village and they were cultivating the sweet land separately according to the previous partition, and they were not aware about the preparation of new survey record of rights jointly, as well as inclusion of self-acquired property being plot number 538 and 69, area 69 decimal incorrectly. It was asserted that the new survey record of right is not conclusive proof of jointness of the parties. It was also asserted that the entry made in new survey record of right was illegal, null and void. The following issues were framed by the learned High Court. The issue number, both the parties led oral and documentary evidences. EW1 was the plaintiff number 3. The trial court considered the materials on record and has examined the evidence of all the witnesses, including the evidence of PW1, which has been specifically referred to by the learned counsel for the applicant. And the learned court ultimately came to a conclusion that it appeared the learned court ultimately recorded the finding with respect to the documentary evidence at internal page 51. So पहला quote करेंगे. Thereafter, the learned court ultimately recorded that it appeared that the parties to the suit were separate business and cultivation, and they started cultivating the suit land separately for the sake of convenience, but there has been no partition in the family by means and bound. It was further held that the survey record of rights, where some of the plots were shown to be in Kabjibara of some parties and some plots in Kabjibara of other parties, and some plots were shown as Sammilit. But such Kabjibara entry was never adhered to separately, and the parties were still joint cultivating merely as per convenience, and there was no partition in the family by means and bound. इसको भी कोट करिए उसी पेज में. रादर यहाँ से ना पेज नंबर 51 से लेकर 53 तक का फाइंडिंग कोट करते हैं, ज़्यादा नहीं, थोड़ा सा है. The learned first appellate court also considered the framed a point of determination in paragraph 14 as follows, whether there is unity of title and jointness of possession between the parties to the suit with regard to the suit lands, inverted comma closed. The learned first appellate court also considered the materials on record and gave concurrent findings based on appreciation of oral and documentary evidences on record. This court finds that the The first appellate court has also considered the materials on record and after due discussion clearly held that there has been no previous amicable family partition between the parties or their ancestors, and there was unity of title and jointness of possession between the parties with respect to the suit land. And ultimately dismissed the appeal. This court is of the considered view that both the courts have taken into consideration both oral and documentary evidences and have come to a finding both the judgments are well considered judgments, and this court is of the view that there is no substantial question of law involved in this case. So far as the judgment passed by Honorable Patna High Court, reportedly in 1989 SCC Online Patna 28 is concerned, in the same case, the same does not apply to the present case inasmuch as in the same case the defendant was able to adequately prove on the basis of materials on record that there was previous partition, and this was fortified by the fact that the parties had even sold property by referring it to be their share, their own share in the property. The defendants in the same case could prove that there was a previous partition, but so far as the present case is concerned, this court is of the view that the defendants have failed to prove that there was a previous partition when seen in the light of the oral and documentary evidences as discussed by the trial court as well as the
And so this second appeal is one of the appellate number 3 lordship Judge Suraj Around and so appeal is
I just do not know. After argument करने के बाद आप कुछ बोलते हैं तो इसका हम कुछ cognizance नहीं ले सकते.
I don't want to disturb also, that's why.
It can't be like this. Dismissed.
Item 25, second appeal 122 of 2025.
Please appellant.
On this matter, suit for a specific performance has been filed by the plaintiffs, the respondents hearing against the defendant first party, the appellant, before the bench.
Just a moment. You are the plaintiff or the defendant?
I am the defendant.
It was allowed suit.
The suit was dated in favor of the
Just a moment. Your defendant number?
I am defendant first party.
First party.
First party.
Suit was allowed.
Suit was dated.
Okay. And then
Then I moved in appeal. That was dismissed.
So you are the defendant, appellant, lost in both the courts.
Both concurrent.
What is the perversity?
Perversity, the leadership, the suit was basically prepared with a prayer for the direction of a specific performance to execute the same deed for the 1/3 sale, that is 829 square feet property out of agreement area 2489 square feet in Schedule A on receipt of the balancing. So, how this, the factual matrix of this case goes that land of 4,978 square feet was purchased by this defendant, appellant, along with his brother jointly from one from the vendor being Domin Rotiai in the year 1990. While the registered sale deed, that was number is being given, and after mutation, the name of these two vendees were recorded in the records of right, registered to, that was recorded. Now it has been announced in the plant that in the year 2009, there arose a requirement to this appellant for some money. So he offered to sell his share of that joint property at the consideration amount of 1,42,000 to the plaintiff and defendant second party. Total in together, three persons have entered into the agreement. The plaintiff and the defendant second party. Second party there are two people there. So there an agreement was entered in 2009. So subsequently with a promise that within 6 months this sale deal will be executed in the favor of the vendor. So this was the contention. Subsequently the promises were not kept up, and then after some notices when the execution of the sale deal was not done, this suit has been brought by this plaintiff against the defendant first party who happens to be the appellant and defendant second party who are performer defendant. Though the defendant second parties have filed their WS, so subsequently they did not intend to pursue the matter. So this suit has been allowed, partially allowed only in favor of the plaintiff. So there is no decree in favor of the defendant second party. So these are the factual.
Otherwise, also in favor of defendant second party, how many decrees have been passed?
Because they appeared and they filed their written statement supporting the claim of the plaintiff.
Even if they support, if they have to claim anything, they have to file a separate suit for themselves, or they should have joined as a co-plaintiff.
Because they were arrayed as defendant second party, so they can contest. There is no requirement of the subsequent suit. So basically, my lord, without going into the factual matters, I'm only categorically I have prepared 5 grounds on all the legal grounds on which I will be contesting this matter. The very first one that I have to say is that the subject
Where
matter.
is it? Where is it? You must have prepared your substantial question of law.
Yes,
It must be there in it.
yeah, it is. Is page number 50.
Yes, please. There are so many grounds you have taken. Which 5 grounds you are referring to?
Well, you have general grounds and there are from the very first one,
Please read it.
whether the degree of specific performance is legally tenable when the execution and validity of the sale agreement are doubtful.
This is absolutely factual. This is not a substantial question of law.
There has to be.
Is there any finding that the agreement is doubtful?
No, that was a plea taken by me, but that has to be the veracity of, because that is the basis of the entire suit. The veracity of that agreement has to be checked, and whether it is a legal document prepared as per the law or it is a forged or have some third of doubt on it. Because there is no, because in these kind of agreements, the very important thing that has to be seen, there has to be an acknowledgement of the receipt of the advancement. So that has to be there. That has never been seen, and that is missing in that agreement. So for that reason, I am saying that the veracity of that agreement itself is doubtful. That is a doubt.
So this is all factual. You want to say that this plea should have been appreciated.
Yes, definitely. Yes.
The veracity of the agreement has not been properly considered.
Yes, definitely. That is one ground. The very second one, whether the court below error in law by granting specific performance of an agreement executed by one co-owner in respect of entire undivided property without partition or identification of sale. So at the very first instance, I have said that in the year 1990, this property was jointly purchased by this
Is
petitioner.
there any bar in selling undivided shares?
There has to be identified, it has to be
If
identified.
an unidentified property, undivided share can also be sold. Is there any bar?
But how it will be executed? Because
It will be executed.
unless and until the share of a person is identified, how can he say be transferred to some other person?
Please stop putting questions to me. I'm just
Sorry,
asking.
sorry, I'm putting question to myself.
Yes. Undivided share can always be sold. The law is well settled. There need not be partition.
Conflicting opinions, my lord. That
We do not know
there
what
has to be first
If
of
there is a
all,
conflicting opinion,
if someone's intend to share or get into
all parties need not join for selling their property. Undivided share can also be sold. So rather, if one of the persons has sold all the parties' properties, then his share is limited to the share of his vendor.
Certain.
That is
That
the
is
law.
there. But even in the suit, there has to be joiner of that party. So my contention is basically one can enter into an agreement, but at least in suit, she should have been because the what the fact says that very initially this property was purchased by this defendant along with his brother, who died issueless, leaving behind his widowed wife, and her wife is entitled to 1/8 share of this suit property. So this is my contention. Now coming to that fourth, that is the fourth one is important. Whether the degree for specific performance legally sustainable when the suit property already sub judice in a prior pending litigation involving ownership, thereby attracting the law of section 10. So what I have to submit at this moment, that this plaintiff, father of this plaintiff, has also lodged a proceeding under section 144.
140?
144 CRPC. And the Bhavi of this petitioner has filed a title suit praying for declaration of the same deed, by virtue of which we have purchased it to be declared as null and void. So that suit was pending. Subsequently, that suit has been dismissed and an appeal has been preferred. So still the subject matter involved in this suit is sub judice in a different suit.
What was the number of the title suit?
The title suit was 147 of 9. Title suit number 147 2009.
It was dismissed.
It was dismissed.
Appeal.
Appeal is pending.
Where is the appeal pending?
Appeal is pending before the London Sessions Judge, Civil Appeal number 10 of 2023.
Pending.
Pending. Now, Your Lordship, the fifth one. I think this is the most vital ground that I will be pressing now. That whether the court below erred in knowing granting a specific performance despite the plaintiff failed to prove readiness and willingness to perform his part of her part of the contract as mandated under section 16C of the specific agreement. So there has to be Lordship in section 16C of the specific performance act, which says that there has to be a readiness and willingness. To that effect, there has to be issue framed. There has to be a specific issue framed by the London trial court, putting the parties into a strict proof, jacket of proof, that whether there is a readiness and willingness for the execution of the subsequent sale deed. In this support leadership, I will be placing a very decent judgment. So leadership may kindly appreciate. Because in this, altogether 7 issues have been framed, but this issue has been left out. Internal page number 20, running page 18. Running page 37, internal 18. Leadership, I will be placing the judgment.
You're placing the issues or you're placing the
No,
judgment?
I'm just placing a judgment on this issue. whether it is required or not. Paragraph 4.1.
Read it.
Now the findings and the reasons given by the learned trial court refusing to pass a degree of specific performance in concern, it appears that though there was no specific issue framed by the learned trial court on readiness and willingness on the part of the plaintiff, the trial court has given the finding on the same and has not suited the plaintiff by observing that the plaintiff was not having sufficient fund to make the full balance consideration all or before 12/2006. Such a finding could not have been given by the learned trial court without putting the plaintiff to notice and without framing a specific issue on the readiness and willingness on the part of the plaintiff. There must be a specific issue framed on readiness and willingness on the part of the plaintiff in a suit for a specific performance, and before giving any specific finding, the party must be put to notice. The object and purpose of framing the issue is so that the parties to the suit can relate the specific evidence to the same. On the aforesaid ground, the judgment ought to pass by the learned trial court, dismissing the suit and refusing to pass the degree for specific performance agreement to self-confirmed by the High Court deserved to be passed in sentence, and the matter is to be remanded to the learned trial court framing of specific issue with regard to readiness and willingness on the part of the plaintiff. On remanding the result. So one of also important aspect of this matter, kind of it is not purely factual but kind of factual. But in this matter, what is happening in the year 2019, 2000 and 2009 itself, that is 7/7/2009, the father of this plaintiff has lodged a proceeding under section 144 of the CRP against this defendant first party. And that proceeding was dropped on 4/9/2009. Why dates are important? Because in between this agreement is alleged to have entered into between the parties. So it is beyond imagination that on one hand, this defendant is contesting a proceeding under 144 with the father of the plaintiff, and on the second hand, he is entering into an agreement with the plaintiff. So this has been done in between of the proceeding when the proceeding was going on.
What are the dates?
The initiation of the proceeding is 17/7/2009. That proceeding was
The
dropped.
father of the plaintiff.
The father of the plaintiff has lodged this against the defendant first party. This was dropped on 4/9/2009. While the agreement is alleged to have entered into between the parties on 12/8/2009. It is in between while the proceeding were pending.
This order has been, the dropping order has been executed, 4/9/2009.
No, that is
That has not been executed. Maybe it has been dropped on account of compromise between the
no.
parties.
Fine. There is a specific statement made.
Statement se kya?
But the drop with a direction to the party to go before the competition.
Where is that? Where is that exhibit? 4/9/2009. Not exhibited.
No.
That's all. Essay number 122 of 2025. Or the learning council appearing on behalf of the applicant. The second appeal has been filed against the judgment in DT dated 22/3/2025 with the valid degree signed on 3/4/2025 passed by learned District Judge Roman C. Devkar dismissing the civil appeal number 20 of 2023 and informing the judgment and decree dated 24/1/2023 within bracket decree signed on 4/3/2023 passed by learned civil judge within bracket senior division bracket closed Roman 3 Devghar, whereby the title suit number 28 of 2013 seeking specific performance of contract was partly decreed. The defendant having lost at the first appellate stage has filed dissident against concurrent defendants. The learned counsel for the appellant, by assailing the improved judgments, has submitted that the trial court did not frame any specific issue in connection with readiness and willingness on the part of the plaintiff to perform his part of the contract. He has also submitted that the learned courts have failed to consider that the father of the plaintiff was contesting a case against the defendant in a proceeding under section 144 CRPC, which was initiated on 17/7/2009 and was ultimately dropped on 4/9/2009. And in the meantime, the agreement of sale was entered on 12/8/2009. He submits that it is almost an impossibility that in the midst of a proceeding under section 144 CRPC, the agreement of sale will be entered into between the parties. He submits that this aspect of the matter has not been considered by the learned courts while upholding the validity of the agreement. The learned counsel has also submitted that the specific performance has been allowed with respect to undivided portion of the property, inasmuch as there has been no partition with respect to the suit property which stood recorded in the name of the defendant and his brother. He says that brother was not even a partner in the suit for specific performance.
Rather in the agreement not.
And even in the agreement, the brother was not a partner. The learned counsel has submitted that there cannot be any suit for specific performance of contract with respect to undivided share in the property. He has relied upon the judgment passed by the Honorable Supreme Court reported in past date civil appeal number 8050-8051 of 2022 within bracket V.S. Ramakrishna versus P.N. Muhammad Ali, decided on 9th of November 2022, paragraph 4.1, to submit that no finding can be recorded with respect to readiness and willingness in absence of specific issue framed to that effect. He submits that the learned court, the Honorable Supreme Court, had remanded the matter by framing that issue for consideration by the learned trial court. the learned counsel has further submitted that one tax suit number 147 of 2009 was pending, challenging, ये कौन सा sale challenge हुआ था?
जिससे हम खरीदे 2019
challenging the sale deed which was executed in favor of the defendant with respect to the property which was involved in the present case. And though the suit was dismissed, the civil appeal number 10 of 23 was pending before the learned first appellate court. Abhi bhi pending. He submits that the sale appeal is still pending. The learned counsel submits that the adjudication of the suit should have been the present suit was barred under section 10 of the CPC. 10 is what?
It is that bar or the subject matter is involved in prior or decided suit or a pending suit.
Did you file any petition under section 10? The petition is required to be filed, isn't it? During the course of hearing, a specific query was put to the counsel for the applicant as to whether any petition seeking to keep the adjudication of the suit in abeyance under section 10 was filed by the applicant. He has submitted that no such petition was filed, but still the court should have suo motu kept the matter pending, awaiting the decision of title suit number 147 of 2009 / civil appeal number 10 of 2023. That's it? Or कुछ नहीं?
That veracity of
the learned counsel has referred to the proposed substantial question of law number 1, 2, 4 and 5. Arguments concluded. I just pass in order, let me see what you want. I've heard you now. I will give a date, I will give a situation.
Password case from supplementary list. Item 403, second appeal 579 of 2017.
In this matter, the appeal was filed against the judgment of performance on behalf of plaintiffs and defendants. And it was a case of the plaintiff is that.
No, I will not permit you senior to enter. पार्ट नहीं चलेगा ना कि तुम तब तक बहस करो फिर मैं आ रहा हूँ. I know. यहाँ पे टाइम पास करने की जरूरत नहीं है. चलिए, I will not permit you to argue then. No.
From J list for finals to item 5, first April 22 of 2008.
Who's for the appellant? Ten of 2008. कहाँ है वो judgment? 10 of 2008. Covered case.
It has been passed in FA 30 of 2008.
FA?
FA 30 of 2008.
They got that order? Covered? Yes, I for the respondent. It's covered. Have you got a copy of that order? Into printing calculation. Printing calculation. April 30 of 2000. This is LR case number 447.
Yes.
LA case number is 5 of 8687. Right? In the first paragraph, only the LR case number has to change. Correct? In para 4 would remain the same. Para 5,
Para 4 has if you take of 2008, which has been
followed
followed.
this. Okay. Then it was remanded. Correct? Then para 6 would remain the same. Intervenor, is there any intervenor? No. In this case, there is no intervenor. Intervenor is not there. Para 6 will not be there. Private respondents?
There is no
Is
intervenor.
anybody appearing for private respondents?
Yes, Lordship, we are here. However, the client has taken the file, so we will not.
So you have your वकालतनामा, right?
Yes, Lordship.
यहाँ पे जो 7 नंबर है, so we will delete 7 also, right?
Yes.
Para 7 में heard Mr. according अपना नाम लिख दीजिए, अपना आप ही साथ में दे दीजिए on behalf of the respondents. He submits that he has no instructions. Should I? Or should I not? Okay. Heard. That should be sufficient. Then para 8 would remain. Correct? Para 9 is the quotation from that judgment. Okay.
Para in case of intervener only respondents.
You see, para 7 I have deleted. Para 7 I have completely deleted. I am just writing that I heard you. Then I have for the appellant and the respondents. Right? Okay. Then 10 would be the same.
The LR case
LR case would be
447.
447. In the next case also LR case would be 447. Correct? I will give a date 15 December should be good. I have given the date 15 December 25. Same date? Right, this will remain. 13 won't be there. Right, this appeal is disposed of. Retain the photocopy of the concerned records. We are asking them to retain the photocopy of the records.
That was with respect to this case. Now, once this matter gets disposed, the entire matter goes.
Entire batch goes. Okay, तो इसका भी जरूरत नहीं है. 15 हटा दे.
Yes, yes. This is the last case.
This is the last case. Alright. This is it. ये किसने टाइप किया था? मुकुल जी का है। उन्हीं को दे दीजिए। करेक्शन हम इसमें कर दिए हैं। This appeal is disposed of. Correct. आप छोड़ दीजिए सर। आप छोड़
सॉरी हम लोग बैठे
कोई बात नहीं, आप छोड़ दीजिए इसको नेक्स्ट वीक।
सिर्फ एक ही चीज हम एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ होना है रिकॉर्ड या उसी दिन
उसको फाइल कर दीजिए।
उसी दिन
इसको ना फाइल में ऊपर डालें। इस केस में लिखिए तो the learned counsel for the appellant has suggested additional substantial question of law in writing which is placed on record. Post in the next week. कोई एक corresponding date दे देना।
Item 6 from date list 1st April 43 of 2018.
This case is ready in all respect. This is also arising out of the same IIT.
So what?
Yesterday, my
उसको कोई मतलब नहीं है, आप अपने केस वैसे
having requested for only one evaluation. Because yesterday,
कल रखे हैं, कल आपका भी सुनेंगे, वो चल रहा है ना जब कल, हाँ तो साथ साथ इसीलिए तो कम से कम खोलिए तो सही, क्या बहस करना चाहते हैं, आपके सीनियर आएंगे कुछ तो बहस करिए। अरे भाई बेसिक फैक्ट तो बहस करेंगे कि नहीं करेंगे?
आज
आपके सीनियर ने बोला है कि आपका आर्गुमेंट रिकॉर्ड नहीं होना चाहिए, ऐसा नहीं है तो बताइए क्या बोलना।
basically I was minority done in that case minority. हम लोग कल
That case is with regard to 71 acquisition. This is with regard to 86 acquisition. Subject is same.
Story is the same.
But this matter has been confirmed by the Supreme Court in number of cases. Same village, same acquisition in number of cases.
सनीचरवा
And
लकड़ा,
identical.
सनीचरवा लकड़ा, arising out of the same acquisition.
Yes, ma'am. It is.
Same acquisition.
86 acquisition. Sukheru Rao, Sanitarwa
Just a
Lakra,
moment.
Bandhanu Rao, and thereafter
86 वाला
Cedar Kunda
तो
is
ये
from
तो
the same
big,
village.
ये big acquisitions है
This is
राइट।
with regard to the village Dumbagu.
Unexplained delay of more than 8 years in appointment of arbitrator. इसलिए सोल्यूशन एंड इंटरेस्ट दे दिया।
therefore हम लोग का भी
उसमें तो इतना स्टोरी है, इसमें
कल
तो
तक
कहाँ
का
स्टोरी?
हम लोग का पूरा कंसेप्ट क्लियर हो जाए only one recommendation that is
ठीक है कल ही रखो, कल सेकंड हाफ में सुनेंगे। सेकंड हाफ का बोल है ना, इसमें तो उसमें कोई लेना देना नहीं है, ये फाइनल डिस्पोजल में है। तो जब भी होगा तब सुनेंगे। क्या प्रॉब्लम है, साथ ही साथ सुनेंगे ना।
वही बस आज की ये प्रॉब्लम है कल हम उसमें बहुत ज़्यादा वर्कआउट किए थे मैक्सिमम हम लोग ट्राई किए तो if my lord arrests them but I will be respecting the
In this case, they have taken only one point whether solatium and interest is due.
that is the only point you have taken, there is no other point you have taken. Solation and interest मिलेगा कि नहीं मिलेगा? Arising out of the same acquisition proceeding. Do you appreciate? Arising out of the same acquisition proceeding, solatium and interest have been ultimately awarded. So how his case is different? ये कौन सा acquisition proceeding है? This is which acquisition?
RAF में ही है.
नहीं वो एक्ट तो सेम है, एक्विजिशन प्रोसीडिंग बताइए कौन सा?
Property acquisition in 1942 and it was
वो नहीं पूछ रहे हैं सर, आप हमको बताइए कि ये कौन सा एक्विजिशन का, रिक्विजिशन का बात नहीं कर रहे, एक्विजिशन बताइए. Date of acquisition.
Date of acquisition is 86 March.
So you were in a party in the repetition?
Yes, ma'am.
3784 of 1998
Yes,
R.
Yes.
You were party?
Yes. We were party. In 3784.
Where is the order of 3784?
Order of?
3784.
Yes. This order.
3784 का ऑर्डर दिखाइए.
हाँ दिखा.
और हमको ये 1386 of 89 का ऑर्डर.
Well, this is.
So that was questioning the.
This is with regard to
3784 of 98. दिखाइए सर.
And this has been confirmed with the FPA. This both orders. And thereafter matter went to the Supreme Court and the Supreme Court also confirmed and admitted the FPA.
Just a moment.
By way of this order, the arbitrator
2626 of 98.
वो अपील में गए थे FPA में against the REIT order 3784.
Then the learned counsel for the petitioner has submitted that the instant case is squarely covered by the order dated 26/7/99 passed in CWJC number 2626 of 98.
2696 is with regard to Senate Munda levels.
2626 of 98.
Yes, sir.
इसका ऑर्डर कहाँ है?
Well, that is not here, my lord, in this case.
जो ऑर्डर दिखा रहे हैं वो तो वही है ना.
That is having another point.
ये वाले एक ऑर्डर की कॉपी चाहिए. CWJC number 1723 of 1990. एक खाली ऑर्डर था, काई क्यों था? इसका अवार्ड कहाँ?
Is
what is the reason given for awarding solution and interest?
Award is dated 5/4/2012.
That's right. What is the reason given by the learned arbitrator for awarding solution and interest?
This is the fourth case, therefore, in the very first case, the 2,000 rupees per decimal has been granted. That has been given with regard to, and with
आपसे पूछ रहे हैं इनका तो ग्राउंड सिर्फ सॉल्यूशन और इंटरेस्ट पर है आप हमको बताइए व्हाट इज द रीजन ग्रांटेड गिवन बाय द लर्नड आर्बिट्रेटर टू गिव सॉल्यूशन एंड इंटरेस्ट because otherwise solution and interest is not applicable.
because there is a delay in appointment of that.
How much is the delay? How much is the delay?
More than 12 years. That has been discussed a lot in para 18. So far, the delay filing of the application and the grant of relief by the approval board is concerned in this proceeding. I am not compelled to question the order of the Honorable High Court, which allowed the writ and directed for appointment of arbitrator after 12 years from the acquisition. So far, scholarship and interest are concerned, true, it is that the Act and rules do not provide for it, but learned counsel for the opposite party relying on Prabhu Dayal and others versus Union of India reported in 1995 supplement volume 4 SCC page 224, wherein scholarship and also the interest were allowed mainly because of the failure of the opposite party in referring the matter of arbitrator after a delay of 5 years. In the instant case, there has been delay of 24 years. In arbitration case number 8 of 93, 2 years ago, and others, Union of India and others, there is others in the land of India that acquired honorable arbiter has been just compensation.
No amount was paid to you. No amount was paid to you.
No, amount was fixed at 2,000.
Amount has been fixed at 2,000. Was any amount paid to you? Prior to the award, did you take any amount?
No, I have received amount.
How much amount did you receive?
That is very 12,000 rupees per acre.
12,000 rupees
Per acre.
per acre. And it is now 2,000 per decimal.
Yeah,
That is 2 lakh per acre.
2 lakh.
So the solution is directed to be paid on the entire amount or on the differential
No,
amount.
the amount which has I have already received, that has been minus.
Where is it?
It is in calculation.
You see?
It is in calculation. I am showing the calculation at the last page. It's the reward.
Show me.
Claimant number is given. Thereafter, serial number in gadget
No.
has been
Where
given.
is the award? Where is the award? The calculation of the award is not there in the record.
It is calculation is there
There.
by the
हमारे पास तो नहीं है.
opinion is there.
Where has he deducted? He has deducted the amount prior to. You see, he computes the amount and then deducts the amount and then calculates the solution.
Yes. Yes.
Or he has calculated the entire amount and then deducted the
No.
solution.
How much received from the deputy commissioner is given, just valuation fixed, and thereafter amount received. The calculation is just valuation in column number E. Thereafter F, how much received, that has been deducted, and thereafter solution has been given.
And thereafter remaining
Yes.
calculation. And after deducting that.
Yes,
दिखाई है थोड़ा सा इसमें। And then 12% interest has further.
Yes. And post-award interest
Is
is
12%. So 12% is calculated on the interest component also, or it is only calculated on the.
This calculation is given by them. The arbitrate has given this.
So I'm not having that calculation. From where do I see this? It is not there in the records. You have not filed it. How do I read that calculation?
I don't know how they have filed the appeal. But in the copy,
क्या बताएंगे सर? वो तो आप ही जानेंगे ना. अपनी कैसे करेंगे? Award कहाँ है? Where is the award?
yes, well, I can see the original copy of the duly signed by the arbitrate.
ये 1 lakh rupees cost भी दे payment किए हैं आप लोग.
Yes, post has been given because they have not. Post has been given only because there is a provision in the act that if uh, the losing party is to pay the cost.
ओ ये है, ये इसको दे दीजिए यहाँ रखो.
The area is 2.2, very first line I am seeing, and that has been multiplied by 2000, and thereafter amount received is 13,942. Thereafter that has been deducted, amount comes, and thereafter 20% and 9% interest from the date of acquisition till the date of award. And
You see, solution method is 20% on F. F is amount received. आप देखिए
No.
calculation
the 20% solatium is
on F.
on 42,000.
आप F देखिए ना, टॉप में देखिए किसमें? ये लिखा तो F में ही है ना?
हाँ वहाँ गलती से लिखा
गलती है ना?
हाँ वहाँ गलती है. That is to be corrected. Well, there are so many. I have marked so many mistakes there, but calculation is correct. जैसे interest at the rate of 9% per annum on F, it is not
On G होना चाहिए ना?
on H होना चाहिए and on G होना चाहिए.
G होना चाहिए. इसका 20% निकालिए तो सभी जी. 20% of
20%.
426058.
हाँ इसका 42 का ठीक है. Calculation is correct.
एक सेकंड देखते हैं.
42,000.
एक
4,26,058.
426058.
उसका 20% ठीक आ रहा है.
कितना?
It is 85,211.
अच्छा और इंटरेस्ट किस पे किया है?
इंटरेस्ट 9% जो किया है वो करना चाहिए था इनको ई और जी पर. सॉरी जी और एच पर. तो ये गलती से लिखा गया है. I am not my calculation I am not.
9% सिर्फ सोल्यूशन का ही दिया है.
नहीं 9% interest.
Interest on solution only.
Solatium and principal. 85,211 and 4,26,050. ये दोनों पर 9% interest from the date of acquisition till the date of award.
9% तो सोल्यूशन में एज पर अवार्ड नहीं. Interest Roman 3 interest from 13,387 on the residual amount to be paid to the claimant. Solution is not the residual amount.
No, it's para 21.
Para 21 में.
Yes, ma'am. Interest from 31/1 and 30/1/1987 date of acquisition on the residual amount be paid to the claimant till the date of award, that is I/4.
Yes. Solation में तो interest नहीं है. Residual amount पर interest. It is only on the residual amount. So आपका ये 9% interest will be calculated only amount after deduction in column number G. G and H पर 9% नहीं होगा calculation.
I will complete. I will personally today night I will complete.
तो देख एक column का calculation दे देंगे तो काफी.
Today night I will.
कहानी तो सेम ही है सबका. Yes. Next week नहीं साथ ही साथ सुनेंगे ना. क्योंकि ये भी तो एकदम same to same matter. There is no difference at all. You have only challenged the solatium and interest. और तो आपने कोई challenge ही नहीं किया. There is no other challenge. Whose conduct will become important? You see, there is no question of conduct of payment. The moment the agreement is not arrived, the ball is in your court. Right? If the conduct of the claimant was important, then the entire claim to get an arbitrator appointed would have been declared barred by limitation or maybe barred by lapse of time. Right? But the fault was on your part, the ball was in your court. That is why even after 44 years, the arbitrator has been appointed, citing that it has been failure on the part of yours to appoint an arbitrator. So there is what conduct do you want to see? You did not appoint an arbitrator. There are no option but to file a writ petition to get an arbitrator appointed. Now you say their latches. What latches? Then the writ petition ought to have been dismissed on the ground of their latches. Yes. So same thing is there in the other record also.
I know, just for next week or
रहेगा तो रोज ही. आप बहस भले उसके खत्म करने के बाद करिए. दोनों का जजमेंट एक ही साथ. Every day it will be there. It's an opportunity for you to argue. I will not confuse.
I cannot.
What do you mean you cannot? Then I will dismiss. Nobody appears dismissed. No. You know the matter. At least this record you should argue. This record you should argue. You don't need the permission of a senior to argue a case before the court. It's a command. You obey. Correct? So this is coming tomorrow. You go through the award. वो अपने सीनियर को करने दीजिए. अपना नोट वोट करिएगा. Conclude नहीं करेंगे. ठीक है? The learned counsel for the parties are present. The learned counsel for the respondent has submitted that the appellant has challenged the award primarily on the ground of award of solatium and interest, as the acquisition was under the provisions of RAIT Act, in which there is no provision for payment of solatium and interest. He has submitted that the arbitrator was appointed after 12 years. Of the date of acquisition. After 54 years. From the date of acquisition.
86 साल में था आर्बिट्रेटर अपॉइंट हुए 2013 में। नहीं 11 में अवार्ड है 5/4 2012।
The Learned Council has submitted that a writ petition was filed being CWJC number 3784 of 1998 in bracket R, seeking appointment of arbitrator, which was allowed by the order dated 16/5/2005 in terms of the order dated 26/7/1999 passed in CWJC number 2626 of 1998 in bracket R. Against the same, LPA number 268 of 2000 was also discussed. He submits that arbitrator was ultimately appointed after expiry of 12 years from the date of acquisition, and therefore the learned arbitrator has taken this aspect of the matter into consideration while awarding solatium and interest. Correct? That's all? He has relied upon the judgment passed by the Honorable Supreme Court in the case of Union of India versus Sanicharwa Lakra in Civil Appeal number 8288 of 2002 and Civil Appeal number 1827 of 2003, and has submitted that in the same case there was a delay of 8 years in appointment of arbitrator, and ultimately the solatium and interest. Ultimately, the claimants were found entitled to solatium and interest. Should I record that it was arising out of
Yes,
the
ma'am.
same acquisition proceedings?
Record has been called for, that is written.
It is arising out of the same land acquisition
Yes,
proceedings.
yes.
The Learned Council submits that the judgment passed by the Honorable Supreme Court in the case of Union of India versus Sanicharwa
In that
Lakra
case, 4 cases.
Supra was arising out of the same land acquisition proceeding which is involved in the present case. That is land acquisition case number.
And you- yes.
And which was acquired by notification dated 13/1/1987.
It is. And
That's all.
MA number 38 of 94, MA number 39 of 94, passed by this Honorable Court, and that matter went up to the Honorable Supreme
What is
Court.
that MA?
It was filed business.
This is the first appeal.
This is first appeal, but another case, they were filed business.
Okay, so what happened in that case?
That was dismissed. Dismissed on May.
Okay, the learned.
And
And the solatium and interest was again.
Yes.
The Learned Council has also submitted that the appellants had filed MA number.
No, well, appellant has not filed. It is the state has filed. Business.
State had filed. RAIP Act में state का क्या काम है?
How state, the Deputy Commissioner is the competent authority under section 2 of the Act. RAIP.
He challenged the award.
Yes.
This very award.
No, in another case.
आप सर ऐसे दूसरा केस का मिक्स मत करिए, आप नोट्स बनाइए, आप ऐसे नहीं एक केस से दूसरा केस को ऐसे मिक्स मत करिए। दूसरा केस है सेम एक्विजिशन प्रोसेस है कि नहीं है, ये सब सबमिशन अगर आपका गलत होगा तो अच्छा बात नहीं है।
सबमिशन गलत नहीं है।
सेम एक्विजिशन प्रोसेस
Same acquisition.
कहाँ से हमको मिलेगा, कहाँ है एमए का ऑर्डर?
I will file all the.
Why do you need to file? You give the number and give the order. आपको उसको फाइल करने का क्या काम है? You can give the order, you can provide it to them also.
I'm just now reading.
MA number बताइए.
MA number 38 of 94.
38 of 94. और दूसरा
132 of 94.
132 of 94.
39 of 94.
39 of 94.
As the same order because it is there in the other case, like between order and that is SPC number. There is also an MA case in the other matter.
I don't know. हाँ बताइए और कोई है?
Against which the LPA has been preferred by Indian law.
LPA number?
LPA number 330 and 331 of 98 are.
98 up. That has been dismissed.
And the order is
That has been dismissed.
that was dismissed.
The Learned Council has submitted that the records of MA number 38 of 94, 132 of 94, 39 of 94 and LPA number 330 and 331 of 1998 be summoned. इसके साथ में लगा दीजिए. बस हो गया?
Dismissed on 19th July 99.
LPA?
Yes.
LPA dismissed on 19th of July 19.
And thereafter SLP preferred. That is civil appeal number 8287 of 2002, 8288 of 2002, and
From where are you reading all this?
it is from my letter. These will be the same equities, same village, same.
तो आप अपना रिकॉर्ड से क्या पढ़ रहे हैं? यहाँ पे कुछ है ही नहीं.
I
You are also seeking time.
have given last time.
This,
Copy of
this,
this.
no, not copy of this. Any petition filed?
No.
Maybe. तो फिर कहाँ से आप अपने पास से पढ़ते रहिए, उसका हम क्या करें? We can't do anything about it. You have not even provided us a copy of these orders and you are reading it from
No, on the last one is the matter. I have provided the as per direction of the court. I have provided to the court as well as my lord has given the number to them to verify that whether it is correct or not. My learned friend Mr. CW is a union of Indian. Supreme Court का भी है.
आप ये जितना भी जजमेंट्स बोल रहे हैं ना, हम तो रिकॉर्ड समन कर ही रहे हैं, वो सारा बंद बना के हमको कर दीजिए और उनको भी देखिए. Because I don't have it anything. Whatever you are saying that you have filed, you have given, it is not there.
No, in sequence again. The right from award, thereafter appeal, if LPA filed, LPA is not maintainable. Therefore, the judgment which I have mentioned before my lord, LP is not maintainable, therefore SLP is maintainable under Article 136. That has been held and that has been accepted by the Supreme Court. And therefore, Supreme Court, they went to the Supreme Court and
ये
Supreme
ना
Court
ये दोनों को एक कॉपी
imposed the court of
करके
approval.
सर जो चीज मेरे पास नहीं है ना, वो ऑर्डर को हम ना देखेंगे ना सुनेंगे ना समझेंगे. I just can't. I don't register things. If you are referring to an order and if the order is not before me, I will not be able to register it. How do I appreciate? If you are referring to an order, how do I appreciate?
I will give by I will
I'll
give
update
by
that.
Copies will come tomorrow.
कोई बात नहीं. उस केस में आपका जो रीट का ऑर्डर है वो भी लेके आइए. आपके वाले जो बैच केस में जो से रीट था ना उसमें भी. इसमें there is a finding of the रीट court that there is no agreement. That is why I am looking for that. The court records a finding. In the present case, admittedly, there is no agreement between the parties. Therefore, there is a clear finding. Admittedly, there is no agreement between the parties. अब आप लोग बहस कर रहे हैं कि बाय कंडक्ट एग्रीमेंट हम देखें, कहाँ से देखेंगे? बाय कंडक्ट स्कोप नहीं है बहस करने का वैसा. When you admitted before the week court there is no agreement, full stop. इसीलिए कल सुनेंगे कल फिर आप तैयार हैं. Pose it at the request of the council, but आप फिलहाल pose this case for further hearing. कोई बात नहीं. क्या है आपको क्या दिक्कत? आपको सुनेंगे, आप तैयार हैं? ऐसा मौका तो हम लोग को मिलता ही नहीं था. आपको मिला है तब अवेल नहीं करना चाहते.
I am just assisting him because I.
In case of funding of
Is the case of union of India because I am not a CDC or.
हम कहाँ फाइनल ऑर्डर करते हैं? I am not passing the final order right now. I want to hear you. काफी नहीं है. देखते हैं कितना तैयारी करते हैं. हाँ. You were waiting for the orders cases to be taken up. We have a meeting right now, so I need to rise. आपको आधा घंटा समझाने में दिए हैं कि आप तैयार हो जाइए. You want an order?